on the type of crime you're looking at and who's investigating it. Let's take, for the sake of argument, we're investigating a crime being committed at the dump in Johnston. If the state police are prosecuting that and they're looking into it, they gather evidence of a crime being committed. And then they would bring it to the Attorney General in Rhode Island, because the Attorney General is responsible for prosecuting crimes under the Rhode Island law. The Attorney General, if he thinks there's a sufficient amount of evidence to bring a charge, could do it in one of two ways. They can bring what's called an indictment, where the Attorney General's office looks at the information and charges the person who's being charged with the crime themselves. Or it could be brought to the grand jury, where they would either issue or not issue an indictment.
Of course, any of us who have watched the Law and Order has said a grand jury, they'll indict a ham sandwich, or as that's, anybody can indict anyone for anything.
Their defense counsel is not able to question or cross-examine, so it's purely all on the state side.
It's all slanted to what the Attorney General wants the grand jury to hear. They bring in the evidence, they present it the way they want to present it. Typically, you're right, no one else gets in. Sometimes, if it's a close call, they might let somebody else come in. The defendant might even be called to testify. They don't have to, because of their right against self-incrimination. The advantage of using the grand jury for the Attorney General is they can issue subpoenas and call witnesses in and really dig into what evidence there is of a crime, as opposed to the investigation done by the state police that's brought to the Attorney General. Without subpoena power, they really can't make people talk.
When does someone have to hire a lawyer when it comes to being arrested? We're talking about a person now, not necessarily someone involved with the dump. But I guess it could be that person who's responsible for the dump is going to need a lawyer. How do you know when someone needs to have a lawyer involved? When
the minute they read you your rights.
Miranda.
The minute they read you your rights. Because if you've committed a crime, if you, the suspect makes any statements subsequent to being arrested, that could be incriminating. But it's always better, the minute they read you your rights, tell them you want a lawyer, they can no longer question.
Right. And even if you didn't commit a crime, but you're being questioned about it,
that's right,
you've got to be very careful. They're fair sometimes, I think, on those people's part as well. If I say I want a lawyer, they're going to really think I did it, even though I didn't, and I shouldn't call a lawyer. Doesn't matter. That you stop the questioning. If you think I did something that I didn't do, I need a lawyer here.
That's good advice. There are times, we've read in the paper lately, people are arrested for drunken driving. That in and of itself, that can be a misdemeanor? That can be a little citation? What's that about?
Here's the problem with that.
It's a volatile subject right now in the state.
And there's
yes, that's why I'm asking.
And there's a lot of different levels in certain things that go into it. Is it your first charge of an alcohol-related offense? Because you could have a refusal charge. And even though it starts off refusal, it's not a criminal case, it's a civil type of penalty.
Refusal?
Refusal to take the breathalyzer.
As one of the charges.
Okay. All right, so let's say you've been pulled over for the first time and you don't take the breathalyzer, you're charged with a refusal, and you pay all those penalties and serve all your time, and then you're pulled over again. The second charge now becomes, instead of a misdemeanor DUI charge, it's a felony. It steps up as you move along that line. And depending on how intoxicated you are, it steps up. And then depending what other activity flowed out of that accident, serious injury resulting, all those types of things, you're looking at a serious jailable offense.
There's some debate about, well, if I didn't get a chance to call the lawyer and I think I'm going to be put in jail for a possible DUI, they have field sobriety tests. Is that the same thing as refusing a breathalyzer? No, I don't want to put one foot in front of the other. I was on medication. I might be a little unsteady on my feet. Are you supposed to refuse that too? Or
the breathalyzer is a chemical test.
Yes.
So you get a reading from that. The field sobriety is more subjective, wherein the police officer is going to observe the individual being charged, or the individual who's a suspect at this time. They're going to observe the individual walking a straight line, you know, head pointing to their nose, and so it's more subjective.
There's actually a few tests, too, that certain judges give much less credence to. One's called I can't say it right, but nystagmus eye test, where
Yeah.
they make you follow the finger and they watch your eyes move and they determine whether or not they're moving smoothly and so forth. And there's a lot of evidence that that's not a reliable test. They also now have a preliminary field, I'll call it, breathalyzer test, a portable thing that they can ask you to blow into. Theoretically, it may or may not be admissible. I'm not 100% sure what the status of that is at this time. The problem you have at that point is driving in any state, but in Rhode Island, it's a privilege. And part of what happens is when you accept that privilege and take it, it comes with certain responsibilities. And one of the assumptions in the law is that you've consented to do a breathalyzer and do all those things once you got behind the wheel. It's inferred consent. If you don't want to have to take a breathalyzer, don't drive. And that's why you can be charged with a crime for or a penalty for refusing to take the breathalyzer.
Might you be better off, though, for refusing and suffer the consequences
Well,
of
in
pulling your license?
Massachusetts, if you refuse to take a breathalyzer, it's automatic loss of license,
Automatic.
regardless of the outcome, even if it's an automatic, because it's a separate charge.
Right.
It's an automatic loss of license.
When I first started in Rhode Island,
6 months, I think.
the advice we always gave at that time was refuse. The penalty was much less severe. It was not criminal in nature, and there was no reason to expose yourself. If there was any chance, of course, if you weren't going to flunk it, take it. But we always said if there's any chance that you're not going to pass it, refuse it. The legislature sort of closed that door on us now because they've increased the penalties for refusal. In fact, the penalty can be more severe for loss of license for a refusal than the DUI charge.
Well, that's
Especially if somebody who drives for a living, they need a CDL, taxi driver, bus driver, truck driver. You can no longer earn a living if you can't drive.
Is what David's saying true in Rhode Island and Massachusetts?
There's an automatic loss of license in Massachusetts.
Yeah.
So it's
Yeah.
6
And
months.
I'm pretty sure it's as
The
severe.
penalties, yeah. Yeah.
Interesting. So let's get back to what happens in a criminal case. Someone's arrested. What's the rest? How does the rest of that play out? What happens next?
All right, and again, it's going to depend on...
Bail.
Yeah,
I want out,
It's
David.
going to depend what you were arrested for. If it's a simple misdemeanor or something of that nature, usually they'll take you to the station, they'll read your rights, then after they charge you and book you, they take your fingerprints, the mug shots, all of that. They'll, if it's not a serious offense, which a misdemeanor usually isn't, then call what we would typically call it bail commissioner. And they can come and set a bail, and you can pay them a fee, and they'll let you go with an appearance date to go to court. If it's a serious charge, they're not going to do that. They're going to then take you from the station to court. Hopefully you were arrested on a Monday through Thursday, or Sunday through Thursday, so you can go the next day, and then you're in front of a judge who will decide whether or not to set bail.
And that's called, is that the arraignment?
That's an arraignment, yeah.
We were speaking about having a lawyer involved. Lawyer, from the time I'm arrested, I say I want a lawyer, and I don't speak to that police officer anymore?
Yeah, except that if they're booking you, you're going to have to cooperate with all the booking procedures.
Yeah, name, date of birth,
Right.
height,
Okay.
weight. It's up to the individual. If it's a serious offense, you're being charged with a felony, then
Yeah, I mean, there are lawyers who specialize in criminal law who I'm
Yeah.
sure get calls all times of the night. Will go down to the police station, try to intervene or see what's going on, get as much information as they can, so that if it's a serious crime and you're going to be taken to court the next day, they can start preparing for the arraignment and make an argument as to why you should be released, either on bail
Or on your
and
personal
recognizance.
which means what? You should define
Okay.
what that is.
So you're brought in front of the judge, and the judge looks at the seriousness of the crime, your flight risk, meaning whether or not you're going to come back to court, what are some other issues as to what the crime was, and determine whether you should be released on your promise to return, which you'll sign a form for. And the part of the promise is you're going to keep the peace and be of good behavior, and you're indebted to the state for whatever your promise is to return. And you don't have to put up any money, you go. As opposed to bail being set, which can be cash bail of a certain amount or set by surety bond, where a bail bondsman can come in and post property so you can be released.